Good afternoon, everyone, and thank you for joining us today. My name is Catherine Pruitt. I'm the Executive Director of the European American Chamber of Commerce, EACC, here in Paris. On behalf of the EACC network, I'd like to welcome you to this event organized in partnership together with the Chambre de Notaires de Paris. Today, we'll be addressing crucial personal and professional questions that Americans and other foreign nationals should consider when moving to France. Our panelists are here to offer insights on a wide range of topics, from family law and taxation to expatriation and wealth management. And for anyone who might miss part of today's conversation, the session is being recorded, and we will share the recording link on our YouTube channel shortly. Some of these topics will be quite broad. The idea today is to use broad strokes and alert you to the main issues. We will not have Q&A session. We will, however, send you slides that go deeper and can schedule calls to go deeper with any of the panelists, and we will share their contact information. Our panelists today are Elisabeth MAURY, Chartered Accountant and Partner at ORCOM International. Elisabeth will delve into the professional aspects of expatriation. She will provide expert insights on social law, including the choice between secondment and expatriation, the impact of residence permits and employment contracts. We will also hear from Pierre-Philippe Gide, notaire in Paris, who will discuss the legal and fiscal aspects of personal and family law in a Franco-American context. He will cover topics such as marriage contracts, divorce, donations, inheritances, and how to anticipate them, as well as the question of housing, in other words, whether to rent or buy. Vanessa TOLLIS, partner and co-head of Gide's New York office, will cover U.S. tax planning for international clients. She specializes in cross-border transactions and tax issues relevant to starting or expanding operations abroad, including U.S. tax treaty eligibility, entity classification, and cross-border equity compensation. Jean Dalby, head of the U.S. desk and member of the executive committee at Banque de Paris Saint-Germain, will discuss financing, wealth management, and taxation for American residents in France. We will also address the challenges of finding French banks that accept American customers. Camille Baudouin, notaire in Paris and discussion lead, will provide insight on legal and fiscal aspects of personal and family law in a Franco-American context, as well as guide this conversation on the key real estate, family law, and business law issues that for Americans and other foreign nationals arriving in France, Now it's my pleasure to hand over to you, to one of our experts. We'll commence avec Elisabeth MAURY. Over to you, Elisabeth.
Thank you very much, Catherine. Good afternoon, everyone. I'm Elisabeth MAURY, partner and chartered accountant within ORCOM International, accounting and auditing firm in La Défense. I'm going to talk about international mobility from US to France and give you some useful tips and tricks. First of all, what is international mobility? International mobility concerns every professional move, such as business trip, mission abroad, reception of subcontractors or foreign employees. It also implies a permanent responsibility of the employer regarding health costs and social charges, personal and professional liability, and responsibility towards the employee and his relatives. When we talk about international mobility, we cannot ignore the issues of secondment and expatriation. It is essential to understand what the type of international mobility project will tackle immigration, labor law, social protection, and tax regime issues. Talking about immigration refers to the administrative documents that refer to the employee situation. Talking about employment law refers to the hierarchical link. If the link of subordination and the control of the employee remains in the home country, we'll talk about secondment. If the link is transmitted for the duration of the mission to the company that will welcome the employee, we will talk about expatriation. If the contract ends with the home company to be concluded with the host company, we will talk about employee transfer. Talking about social protection regime, that is the key point here. If the social security regime is maintained with the home country, then it will be a secondment situation. If the employee is subject to the mission country's social security regime, then it will be a situation of expatriation. Talking about tax regime, it is the tax residence that will determine the employee situation. It is determined depending on criteria defined by tax conventions. In terms of immigration rules, what are the authorizations? Regarding immigration, there are different existing statutes defined according to the conditions set by French law concerning entry, residence and access to work conditions, the person's personal situation and the reason for his stay in France. But regardless his status, it is crucial to look at the person's work authorization, visa, and residence permit. Then, the different permits. To access French territory, foreign people generally need a passport along with another immigration document. There are three types of documents. The visa, that allows you to come to France, the residence permit, that allows you to stay in France, the work permit, that allows you to work in France. To be able to work in France, non-Europeans must have a work permit, allowing them to carry out an activity as an employee. And be careful, a residence permit is therefore not automatically a work permit. Work permit can take three forms: a residence permit equivalent to a work permit, a residence permit and a separate work permit, a visa for both residence and work permit. The type of immigration documentation depends on the nature and duration of your stay in France. Let's have a quick overview about the different permits. First of all, short-term tourism or business stay under 90 days. It is important to anticipate your stay in France and gather all the necessary documents. In principle, for entering the French territory, US nationals don't need a visa for short-term tourism or business stay, less than 90 days within a 6-month period. But it is required to have your passport issued less than 10 years and valid for at least 3 months after your departure date. Keep in mind that the 12 pages US emergency passport is not recognized by the French government as a valid document for a visa-free entry into France. Now, tourism or business stay over 90 days. To enter into France for a stay over 90 days within a 6-month period, US nationals need, depending on their situation, a visa, a travel document, for instance, ordinary passport. Any other additional documents may be requested. When you need a visa, you need to complete your application on the French online portal, France Visa, and submit it to your local visa center. Then you can track your application status. Upon your arrival in France, you may be subject to administrative obligations to transfer your visa into a regular residence permit. The obligations can differ depending on the visa issued to you. The best advice I can give you is to anticipate and prepare your stay in France. I recommend you to regularly check on the French embassy in the US website to get updated information. Make sure you have everything ready and valid documents before you go, especially if you are traveling to France for reasons other than business or tourism, such as employment, study, or internship. You must obtain the appropriate French visa for that purpose before you leave the state. Now, let's quickly focus on health and insurance coverage when you are expatriate or secondment. When you are an expat, since 2016 and the introduction of the universal health protection, anyone working in France can benefit from the coverage of their health expenses from the beginning of their activity. Therefore, if you have a professional activity in France, you are entitled to cover health costs without waiting periods. Be careful. You are not covered by the French social security system until you have a professional activity in France. However, if you are a permanent and regular resident in France, that is to say for foreign nationals with a residence permit, after a period of 3 months, you can apply to the primary health insurance fund of your place of residence to be registered to the universal health protection on the basis of residency. The primary health insurance fund will examine whether you qualified for coverage of your health expenses on residence criteria. Membership cost will depend on your resources. The French-US agreement does not provide for any coordination provision for sickness and maternity insurance or family benefits. If the family members continue to live in the US, it is necessary to contact the previous US health insurance institution to see what their rights are under US legislation alone. When you are second, in principle, you don't benefit from the French scheme and you remain affiliated to the American Social Security scheme as allowed by the Franco-US agreement on that matter. Health expenses should be sent to this insurance. Talking about employment as a foreign entity, it is essential to determine under what legal structure you will be hiring your employee. Choosing a right legal entity, set up a representative office, which is mainly used to evaluate market before going for full commercial activity and conduct marketing plus non-transactional operations. Set up a branch, which is an extension of an existing company abroad. The branch is legally dependent from the parent company, but fiscally independent. And then set up a subsidiary, which is legally and fiscally independent. There is naturally no ideal structure. Choosing one of these legal structures will depend on your project in France. Miscellaneous criteria must be taken into consideration, such as the activity, social and tax regime, willingness to partnership or responsibility. It is advisable to seek legal advice to determine what would be the best option for you. In any case, the entity will be registered to the commercial court, will get a SIRET number and code NAF that will determine a possible collective bargaining agreement to apply. When hiring an employee in France, it is essential to choose the right type of working agreement. In France, the writing of working agreement and applicable rules will depend on the type of contract you're going to put in place. 4 main types of contracts: apprenticeship, temporary contracts, permanent contracts, and fixed-term contracts. Then, there are some important labor rules to know when considering the employment terms and conditions. Work duration. In France, the maximum number of working hours is 35 hours a week. Any hour worked over the statutory weekly limit is considered overtime, which entitles the employee to a wage supplement or an equivalent compensatory rest period. There are also limits to the number of hours beyond which no further work may be requested, and last, after 6 hours of work, the employees must benefit from a minimum rest break. Then salary. The employee must be paid at least the minimum legal wage, what we call in France a SMIC, which is today 11.65 per hour, or 21,203 euros per year, or minimum wage provided by the collective bargaining agreement. It is also important to be consistent when determining the employee salary with regard to the other employees of the French entity to be compliant with the principle of equality of treatment. It is also be determined his position in the organization with regard to the other employees, the type of work duration he will be eligible to, and possibly specific clauses you would like to include in the agreement. Thank you all for your attention. Feel free to contact me for any question you may have for a possible conference call to explore all the subjects in detail, which requires a lot of time to discuss. Thank you.
Thank you, Elisabeth.
Thank you, Elisabeth. Now I have a question for Jean. Upon arrival in France, I think one of the first concerns for an American will be to open a bank account. They say that for an American citizen, opening a bank account in France is very complicated, like an obstacle course. Is this true? Is there any specific requirements on the part of the banks that might ease the process? Can you tell us more about this?
Yes, absolutely. Hello, my name is Jean Dalbis. I'm half French, half American. Nobody's perfect. I live in France. I've been living in France all my life. I was in the banking sector for all my career. And with the time coming, we saw many regulations. Started with QI, Qualified Intermediary, then FATCA, and we realized that being American and having an account in outside the US is complicated for banks because banks have reporting obligations towards the IRS and with very heavy sanctions. But not only that, it's not only on the tax aspects that it's complicated, it's also for regulatory reasons. In a nutshell, you must also make sure that when you have a US customer, all the financial instruments he will subscribe have the correct market authorizations, and that's not an IRS issue, it's a SEC issue. So there are two ledgers actually of regulation that you must comply with to open accounts to Americans. And that's why many banks just say, I'm not going to go into this mess and just refuse and not even talk to Americans. So that's why maybe some of you Americans in this webinar have had the experience that, are you American? Yes, goodbye. We at Banque Saint-Germain, we're a subsidiary of Odo Group in Paris, and we decided to focus on the issue. And digging in the regulation, we realized that, well, we built a capacity to open accounts to Americans. So point one, cash accounts, actually, it's not a real problem. You will, as an American, you could find easily large retail banks that would open just a cash account. But often, those banks would offer limited services, and you would not be satisfied with if you need anything else than a cash account. So
Mais si, c'est pour ça, mais je voulais pas...
Microphone key. There you go. Merci. Thank you.
Vous m'entendez bien? Okay. Second point, W9 or nothing. What does that mean? That means that when you're a US citizen, you have a social security number, and you must file a tax reporting every year to the IRS wherever you live. That was integrated in the American history since the Civil War. Some citizens of the US didn't want to fight the war, so they fled the US. And so in those times, the Congress, back in the 19th century, the Congress decided to submit those persons to the taxes, even though they would not be residents of the US anymore. And today, the US is the only country with Eritrea in Africa to actually consider as reporting obligations, tax reporting obligations to citizens which are not resident of the country. The second point is very important, the W9 or nothing. The bank will not open an account if you're not able to provide a W9 as an American. That would mean that you're not in compliance with the IRS, and no bank, no reasonable bank would take the risk to open an account to a US citizen without a W9. Third point, This is very important. We try to avoid absolutely what I call the DIY clients. The customer that thinks that he can file himself the French tax declaration and the US tax declaration. Administrative burdens are really too heavy to be borne by a non-specialist. And our experience is that when you're in a DIY situation, you will make mistakes, and you will consider that the bank is liable for your mistakes. And so we would not, as a bank in France, we would not actually onboard a client that does not have at least a CPA and sometimes a tax lawyer. Fourth point, investments. You must know that, so we're not talking about cash accounts anymore. We're talking about investment, because when you open an account at a bank, you often want your bank to manage the portfolio for your pension and your personal assets. And I must stress out that many highly classic products in the French market, like assurance vie, mutual funds, SICAV monétaire, structured products, are actually absolutely toxic for Americans and trigger regulatory problems for the bank, but also in many cases double taxation and reporting infernos. So be very careful when you open an account at a bank and you ask for investments. Make sure that the bank is really drilled and actually has a US desk and is really drilled dealing with American citizens for their investments. So these are all bad news, but actually there are two good news, very good news, and welcome to American citizens in European and French banks. The good news number one is French and European regulations are highly protective to individual clients of banks. Solvency protection of banks, the regulation of solvency for banks is much stronger and stricter in Europe than in the US. That doesn't mean that a bank in Europe will not have any problem, but probably the authorities will see that much earlier. And in situations of liquidity we've seen recently in the US, in the Silicon Valley for banks, could not occur in Europe. That's very important. Also, so that's of course asset protection and consumer protection, because you're American, you're a resident of France, so you benefit from all the very protective rules that protect individuals in their relationship with banks, and that's really important to consider. And the last good news, and there is good news number two. In certain investment fields, it is very interesting to have a blue passport while you are a resident of France. These mainly for tax reasons. And I will not keep the suspense long and pass on the hand now to Vanessa TOLLIS, who's going to tell you everything about that. Thank you.
Thanks, Jean. My name's Vanessa TOLLIS. I'm a partner in the New York office of Gide Noel. I specialize in U.S. cross-border tax issues with a particular focus on tax issues arising between the United States and France, both inbound and outbound. So I'll be speaking today from the perspective of the U.S. tax rules and some of the red flag issues that Americans moving to or living in France should keep in mind. I think, as everybody's aware, tax systems, in France and the United States are complicated. So as Catherine said at the beginning, this is a high-level flyby of some of the main issues. But The devil is always in the details, and it's really difficult to make generalizations because every circumstance is specific. But echoing what Jean said, I would say that a little bit of planning at the beginning, even at some cost, can go a very long way to making for an easier and more compliant years ahead with your investments and with your situation as an American in France. Saving money at the beginning by not advanced planning with the right professionals can lead to disaster down the line. And I'm sure all of us have seen that in various cases. It's very difficult to undo a bad tax situation. It's a lot easier to plan in advance for a good tax situation. So the first point I'll make, which Jean already highlighted, is that U.S. citizens are taxed on their worldwide income, no matter where they live. So even if they move to France and become a French tax resident, they are still considered a U.S. taxpayer. They will continue to file U.S. tax returns every year. The complication is that France will, of course, also see them as a tax resident of France. And that's where you have a possibility then of double taxation, where both France and the US are taxing the same income. However, fortunately, there are a number of regimes in place that function to help Americans living abroad avoid double tax. So as a result, for the most part, Americans moving to France should not experience double taxation if their situation is relatively straightforward. Salary, basic investment income from certain investment profiles. However, once an American starts venturing into foreign investments, particularly equity investments in French companies, French equity compensation plans, there are disconnects in the way that the US tax system approaches those products and the way that the French system does. And those disconnects can create for more complicated analysis about how to apply these double tax avoidance regimes. So to avoid double tax, there are three primary opportunities. The first is applying the double tax treaty between the United States and France. The second is the foreign tax credit rules, which can apply both under the treaty itself and also to some degree under the US domestic rules. And the third is the foreign earned income exclusion and the foreign housing cost exclusion, which is a very specific set of rules under the US tax code. So the tax treaty is generally available to individuals who are tax resident, either in France or in the United States. It functions to allocate taxation of certain types of income between France and the US, and it also provides for very specific foreign tax credits as a mechanic to avoid double tax on what the US will consider foreign source income, which will include income derived from sources in France. So salary earned while, compensation earned while working in France will be considered foreign source income from a US tax perspective, or dividends paid to you from a French company will be considered foreign source income. One important point is that all of the US tax treaties have what is called a savings clause. And what that is a saving to the United States of the right to tax its citizens. So going back to the fact that US citizens are taxed on their worldwide income, a treaty doesn't change that system, but it does give opportunity for alleviating the double tax. So by claiming the benefits of the foreign tax, of the tax treaty, and in particular the foreign tax credits, effectively an American living in France will generally only pay the higher of the French tax or the US tax on their income. And because France is a generally higher tax country, ultimately the US tax is normally offset completely by the French tax. And so the American living in France will typically be paying the French tax. A few special provisions of the treaty that I just want to flag is And Jean mentioned the US investment income under Article 24 of the treaty. France will generally exempt from French tax certain US source investment income, like dividends, royalties, capital gains, as long as they're generated from US investments that are held by US citizens who are also French tax residents. So this is a special treaty benefit for US citizens that are resident in France, and it's applied structurally via a tax credit system on the French side. As a result, for Americans who are moving to France who maintain, a US-centered investment portfolio, they can greatly benefit from that provision. There's also a special provision for French pensions where, notwithstanding the US savings clause, the treaty can also provide that French pensions will only be taxable in France, even when received by US citizens. So again, it's very specific to exactly what type of pension profiles we're talking about, but it's something to keep in mind. The other system that I mentioned for avoiding double tax is the foreign tax credit system. A few general points on that is the fact that there are risks to accessing the foreign tax credits when there are disconnects between the French and the US rules, either regarding the timing of recognition of income or the characterization of the income. And this is particularly true. We see this a lot with equity compensation plans. So if a US citizen working in France is benefiting from a free shares program or a BSPCE program, there are some very careful planning that might have to happen, because the way that the US and when the US will tax income that it considers to arise from those kinds of instruments is different than the French domestic system. And the treaty doesn't always apply in a very direct way to resolve those issues. One thing that was very good that happened in 2019 is that the French social contribution taxes, the CSG and the CRDS, were finally definitively classified as eligible for foreign tax credits. So before 2019, those French taxes were not available to offset US tax. Now they are. So that's something to keep in mind. One aspect that remains unclear is in the United States, we have an additional tax on investment income called the net investment income tax of 3.8% that applies to dividends and gains and other kinds of passive investment income. Right now, it is not available to be offset by French tax on the same income, but there is a court case that is winding its way through. The taxpayers, which was actually an American citizen couple living in France, won their case, but the IRS has now appealed. So we'll see where that goes. But I think many in the US tax bar, including myself, believe that this is an income tax and it should be covered under the US-France treaty. So that will be helpful. I'll just briefly say that the foreign earned income exclusion gives the ability, it's a domestic rule, it gives the ability for Americans living abroad to exclude up to around $126,000 of income when they are living abroad. So it's just excluded from US tax. It's obviously subject to French tax. It seems very good on its face, and it often is. However, in a high tax country like France, a lot of US citizens will actually be better off not using that exclusion and instead using the foreign tax credit system because of the fact that French tax is higher, and also the fact that you can use the foreign tax credits and carry them forward for 10 years. So there's when you're doing sophisticated tax planning, you can really become more efficient with the use of foreign tax credits by planning ahead for future years' income as well. There's a lot more to say. I don't want to take up too much more time. I'm just going to flag that there are a couple of anti-deferral tax systems in the United States. And when Jean had mentioned that there are certain investment products that are almost toxic for U.S. citizens to invest in, he's on the U.S. side, it's usually because those investment products are called PFICs, which is a passive foreign investment company. An equity investment in a passive foreign company like a mutual fund or any kind of passive vehicle, meaning it's not, you know, an active company making widgets or providing some kind of service, subjects the U.S. Equity holder, the U.S. shareholder, to a very punitive U.S. tax regime that taxes at the highest rate of 37%, gives absolutely no allowance for any special U.S. tax benefits like the lower capital gains tax rate, and generally also applies an interest rate across the holding period. It's really a mess. There are ways to mitigate the bad tax results of a PFIC investment, but it requires making certain elections that have to be timely made in order to apply. And, you know, I've talked with many people who didn't know they had the option to make such an election. By the time they realized the mess they were in, it was too late, and there's no effective way to really retroactively do that in an efficient way. So there's, you know, that's another red flag. If you're making any kind of equity investments in France or elsewhere outside of the United States, to understand in advance what the tax repercussions will be in the US and to plan accordingly. So with that, there is more to say, but I'll leave it there, and I'll let Camille take it up again.
Thank you, Vanessa.
Thank you. So while preparing this webinar, Vanessa, you pointed out that US taxation is subject to further evolutions, so we always have to remain cautious. And this actually rings a bell here because, as you all know, there's a big context here about tax evolutions. We're going to point out two specific taxes here that might be interesting for Americans coming to France. I want to talk about wealth tax, impôt sur la fortune immobilière, and inheritance tax. And as you know, these are two questions that are connected to real estate investment and also inheritance settlement questions, both questions which fall in the scope of our missions as the French notaire. So I wanted to make a quick reminder on the role of the French notaire. I know that many of us are attending this webinar today, so I'll make it quick. The thing is, I don't want to translate the word notary because I actually want to highlight the differences between the French notaire and what we call notary public in the US. These are two very different professions. Basically, in France, a notaire is a legal professional with a unique and significant role that is very different from the notaries in the United States. We are appointed by the Ministry of Justice as public officers, and our main responsibilities include drafting and authenticating documents, preparing, certifying legal documents such as property deeds, mortgages, wills, marriage contracts, for example. We also certify these documents as legally binding, and we provide a guarantee of their authenticity. We also handle all types of real estate transactions. We provide legal advice, and we are also in charge of safeguarding these legal documents. So we could say that French notaires combine the roles that in the US might be split between lawyers, public notaries, and probate courts. And our profession provides a high level of legal insurance as well. So returning to the question of real estate investment, one of the questions that the Americans coming to France while expatriating to France might ask themselves is renting or buying. So very quickly on the renting part, there are mainly two different types of leases. I'm talking about the furnished leases and non-furnished leases. I'm not even talking about short-term rentals because this is a whole other topic. So about leases, one thing that is common to both types of leases is that there might be a ceiling on the rents, and that is the case in Paris, for example. So quickly for unfurnished leases, the lease is generally signed for 3 years, but renewable. The tenant may give a 3 months notice and 1 month, even in certain high pressure areas. And the landlord must give a 6-month notice to terminate the lease. When it comes to furnished leases, the duration is for 1 year, renewable as well, and the flat must be equipped with sufficient furniture and fittings for immediate use. And the tenant may give a 1 month notice, and the owner has a 3 month notice to terminate the lease. So that was for renting. For purchasing a property, which is more of the notary's liability, I want to say that foreign citizens, including Americans, can buy property in France under the same conditions as any French national. There's no actual differences. Of course, there might be some on the banking side, maybe for getting a mortgage approved and that type of things, but this is, well, of course, the whole financial question. One thing to mention as well is that the purchase of a property does not confer any residency rights. So if an American wishes to live in France, he still has to take the necessary steps to obtain a visa or a residence permit. So when buying, the bigger question for the notaire will actually be who is buying. So the acquisition can be made either personally or within a company. So let's start with the acquisition made as individuals. So again, the bigger question here will be for married couples. The notaire will raise the question of the matrimonial property regime. The question is who will own the property, under which proportions? Can you sell a property that you bought individually without your spouse's consent, for example? All these questions are set by the matrimonial property regime, and that also sets the regime of the debts for the couple. So again, this matrimonial regime question mostly comes into play when buying or when a spouse dies or when a couple divorces, since it is then a question of dividing up the assets belonging to both spouses. So for a French court, in the absence of a marriage contract or designation of applicable law deed, a couple's matrimonial property regime is defined by the law of the country where the spouses established their first common residence after marriage. That means that for a French court, the matrimonial property regime of a couple who settled in France after the marriage will be governed by the law of France. So that would be a community property by default. But the thing is, most American courts would apply in such case their own laws to the liquidation of the spouse's assets, whatever the historical or present roots of the couple. So it is therefore strongly recommended that Franco-American couples freeze their legal framework governing the matrimonial property regime. That is usually done through the prenuptial agreement. We call that the contrat de mariage, or in American, you can also say a prenup. So the couple is free to choose whether to use a French marriage contract or an American prenup, depending on their ties with each countries. But in both cases, it's really important that the future spouses make sure that their contract will be recognized on both sides of the Atlantic, since no one can know in advance which court will rule on the liquidation of the matrimonial property regime, particularly in the case of a divorce. So we recommend, as notaires, a few measures to ensure that French marriage contracts are recognized abroad, especially in the United States. So these conditions are additional to the French law minimum conditions, but they are considered indispensable by many American courts. So first of all, an independent representation of each spouse by a different lawyer. Secondly, the existence of a sworn translation of the marriage contract in presence of an English-speaking spouse. And thirdly, including in the contract an appendix containing an exhaustive statement of each spouse's assets at the date of signature. So that's the idea of full disclosure between spouses. So these are mainly the questions that the notaire will raise upon buying a property in France as individuals. But many questions arise as well in case the purchase is conducted through a company. So, for example, whether we should choose a French or a US vehicle for this property. Many differences on the taxation will also be the consequences of this choice. A specific warning as well, trusts are not recognized by French law. So American families that are used to trust and have created trust because that's the favorite approach in the US, they might find themselves facing many difficulties that were not expected, and also a heavy taxation. So we know that US trust structures are used for inheritance planning, but they are particularly tricky here. So it's highly recommended to avoid them, or at least to plan ahead with French and US advisors. Another question, which is also a question dealing with inheritance settlements, is that whether we should include the children while buying a property here in France. For example, if we choose to buy the property through a company, should the children be involved as partners of the company from the start? So on this question, of course, there are many criteria that apply. The choice of the different forms of purchase will have consequences in terms of taxes, of course, but not only. So as we said earlier, taxes are evolving, sometimes very fast, and taxes should not be the only reasons for choosing one or the other system. For example, and as I said, I don't want to insist too much on the wealth tax issue because this is probably going to change in the future, but one of the reasons we could choose to have children as business partners of the company that's buying the property in France is that there's a 1.3 million threshold under which there's no wealth tax involved. And if, for example, the children are within the company, then we will look into each child or each business partner's share out of the property to know whether there's submitted to the wealth tax system or not. So, well, all these questions might evolve in the future. I don't want to describe the details of wealth tax, but again, a company can also ease the process for estate settlement. And this is now what Pierre-Philippe is about to explain.
Hi, everyone. Yes. So I will talk about the basics of French international law. We have two main principles in France. So we have the forced heirship and we have the testamentary freedom. So the forced heirship is basically the concept that means a portion of the deceased person estates will remain to his children, and it depends of the number of children. So when you have one child, 50% of your estates will go directly to the child. If you are two, it's 66%, and if you are three or more, it will be 75%. The free portion that remains we must apply to a will and will go directly to the spouse or anyone you want. So it's a reason we insist with the forced heirship, because it's not applying in the US, and it's really different with the France and the French law inheritance. So if you do not have any will, it will be the intestate succession must apply. So the rule are the same. The systems follows a hierarchy between different level. So if you do not have a will, the first level of your heirs will be your children, and if you have none, it will be directly to the spouse and your parents. The second levels is the parents and the siblings, and the third level, it will be your grandparents and the other relatives, especially nephews or cousins. So it's a reason also in France we recommend to make a will, and that is also the difference between the US system and the French one. If we have three types of will. The first one is the holographic will. This will is really uncommon for the American citizen because it's the will be writing by the testator, sorry, and it will go directly to a notary, or it can be kept inside the house, for example. Usually in the US systems, we prefer to have two witnesses. And it's a reason we recommend with the US citizen to have an authentic will. And this type of will in France will be drawn by a notary in presence of two witnesses. Or it could be also with two notaries. And the last type of will, and we do not use a lot, is the mystic will. So it's the reason I will not talk about more about this type of will. But after all those wills, we have another problem. It will be the conflict between which law must apply for the inheritance law and for all the estates in the US and the estates of France. So for the EU countries and for the France, especially for the French law inheritance, we have a general rule. So the law of the country where the deceased had their last habitual residence will apply. For example, if the deceased has his last residence in the US, it will be the US system and the US inheritance law will apply. If it's the last residence in France, it will be France and French law. But you have the choice of the law. So with the will, you can expressly choose one or the other. Especially, you can just choose your nationality law. So if you are a US citizen, you can only choose the US inheritance law. Okay, so it's also really complicated because sometimes we want to choose the French law for the French jurisdiction and for all the estates in France. And all the estates in the US, we want to choose the US law. That will be not an option with the French international law. Also, with the wills, so as we spoke about the authentic will or the holographic will, you have to choose. And we recommend to choose one, because if you do not, and especially if you have a will in the US without saying anything, and you are and your last residence is, for example, New York City, it will be the French international law will apply. So with this example, you have a will in the US. Your last residence is New York City. So according to the French international law, it will be the American system, and especially the New York City and the New York State inheritance law will apply. But in New York City, and especially New York State's inheritance law, the succession law is divided between estates and real estates and other assets. Especially all the real estates, if you have real estate in France, it will be the French inheritance law will apply. So even with a will, we can have two inheritance law will apply. American as New York inheritance law, and as French as French inheritance law for the real estate, only real estate in France. The reason we recommend really hardly to choose to choose the law directly in the will. Yes. And finally, we have another red flag. That will be the compulsory withdrawal right. We call it also the to restore the forced heirship. So even if you have a will, you cannot disinherit your child if one of your child, or even if a citizen, a US citizen, has his last residence in the EU or in France. With the French law, especially the Code Civil, the heirs will be able to request to the French court to apply the forced heirship recognized by the French law. So we recommend also with all your estate plannings to have a meeting with advisor and counselors as attorney for the will in the US and French notary in the France. Finally, it's about the gifts. We talked about before. Especially you can provide and you can have gifts between you and your children, for example, or even with your spouse. But we have also a limitation with taxes. So there are limits to how much can be donated tax-free. So between parents and children, it will be 100,000 every 15 years, euros, especially, and between spouse it will be 80,000 euros approximately. After that, we apply a progressive rates ranging between the children and the parents. It begins with 5% of the gifts, going to 45% for if you are more generous. Yes, and for the spouses, you have also another rate ranging, but be careful because all those taxes applying, especially for gifts between spouses, but for inheritance and especially for succession, there are no taxes between spouses. That is the only arrangement we have in France. And that's it with all the recommendation. I did not speak about the trust because, as Camille said, is really complicated, and there are a lot of tricky problems, especially with taxes. So we recommend also, if you have trust and if you have one, or multiple, to have any advice from a French notary and your attorney in the US. Yeah, thank you.
Thank you so much, Pierre-Philippe. Camille, did you have a last word that you wanted to say?
Yes, we don't have much time left, but I just wanted to ask Vanessa if she had any comments, very quick comments considering the time left, on the estate tax treaty between France and the US, to understand the major concepts and the major ideas.
Sure. I just very quickly, a U.S. citizen is also continues to be subject to U.S. estate tax. So moving to France doesn't change that, but there is a separate tax treaty between the United States and France covering estate tax. So similarly allocating tax between the countries, and that is something that requires definitely advanced planning. And as you highlighted, there are structuring like trusts that happen on the US side, nu propriété and usufruit on the French side, and there aren't direct counterparts on either side for those. So they require special attention from the French side and the US side to make sure that that you're not in a terribly tax inefficient situation, which can happen. So the red flag is that you should definitely get advice.
Thanks to all of you. It was also when, if Pierre-Philippe was speaking as an American, there are a lot of things that you don't realize, or a foreigner you don't realize, and you find out afterwards. And each of your presentations, I think we joked, Elisabeth, that we could go into your area for about 2 hours, and I think very easily with each of you it would be a solid hour of going into these subjects. The point is really today to point out some red flags, some things to be aware of, and to go deeper. As I mentioned, we'll share the slides, we'll share the contact information. Please don't hesitate to reach out with us here at the EACC to see how we can answer some questions. There will be some. I have some myself. I just want to really thank all of our panelists here. It's really been a pleasure to be with you and work with you on this. Thank you, Camille, for the pre-work you've done with us to organize us here on this session. And thanks to all of you for participating in this call on behalf of the EACC and the Chambre de Notaires de Paris. I wish you all a good afternoon and a lovely evening. Thank you.
Thank you.
Thank you. Bye.
Bye-bye.